Hello, my name is Tony Liu and I'm the founder of Focus Law. We help business owners break free from dishonest partners and bad deals. Now, let me ask you a question. If one of your business partners woke up tomorrow and decide to sue you, could they actually shut down your company? Not metaphorically speaking, but I mean literally. Freeze your bank accounts, take away control from the management, and put a court-appointed receiver in charge of your business. That is exactly what one shareholder tried to do in a California restaurant business. In this case, show why understanding the rules matters more than most owners realize. Here's what happened. A successful, closely held restaurant had multiple owners. They worked together. They managed the business together. And over time, the relationship fell apart. Sounds familiar? The accusations started flying. Financial misconduct, the mismanagement, unfair treatment, and one shareholder who was also the president made a bold move. He went to court and asked for the nuclear option. Shut the company down, freeze the finances, and appoint a receiver to run a business. For a moment, it worked. The trial court granted the injunction. The receiver was appointed, and the business was suddenly under the control of the court. And then the other owner appealed. And this is where the case becomes incredibly important for the business owners. The appellate court didn't decide who was lying, who mismanaged the company or mismanaged the money. Instead, it asked two very basic questions. First, was the company even properly brought into the lawsuit? It wasn't. The owners were served, but the corporation itself was never served. And in the eyes of law, the company is a separate entity. It's just kind of like a separate person. No service means no jurisdiction. And no jurisdiction means the court's order were legally void. Second question, did the shareholder even own enough of the company to bring this type of lawsuit? He needed at least 33 1/3%. He only had 22. And he claimed that he bought more shares, but the paperwork pointed to the wrong company entirely. No proof, no standing, no case. The injunction was reversed. The receiver was removed, and the attempt to shut down the business collapsed. Not because the conflict wasn't real, but because the legal foundation wasn't solid. And here is the real takeaway for the business owner. Titles don't equal power. Handshake deals don't equal ownership. And the sloppy documentation, they can cost or save a company. If you are in a partnership that feels strained, if the ownership changes were informal, if someone is threatened to take legal action, this is the moment to pause and get some clarity. Because when dispute escalate, the leverage belongs to the side that prepared before the lawsuit even happened. If this sounds familiar, pick up the phone 714-415-2007. Let's have a conversation. Or forward this video to someone who needs to hear it. The right strategy applies early can be the difference between losing control of your business or keep it intact. Give me a call, 714-415-2007.